All right, Tuesday, federal judge just changed everything. Trump's team, complete disclosure, no exceptions. According to court documents filed yesterday, every communication, every document, every witness statement. I've been going through the 47-page ruling. Here's what I found. The order's specific. $2.3 million in legal fees already spent fighting this. 127 emails they didn't want released. Judge said, no, not requests, orders. You saw the headlines. Here's what they missed. Quick context. Donald Trump, former president, currently facing multiple legal proceedings across different jurisdictions. The issue, his legal team has been fighting document disclosure for months. Timeline, fast version. Months back, prosecutors request financial records and communications. Weeks ago, Trump's lawyers file motions to block. Last week, judge signals patience running thin. Monday, emergency hearing. Tuesday, this ruling drops. That's the setup. Now the documents. What makes this different from previous battles is scope. We're not talking about one specific transaction or one conversation. This order covers everything related to the case. Communications with advisors, financial arrangements, meeting notes, digital records. Judge's reasoning centers on what she calls pattern of delay, not her first warning to this legal team. And according to official filings, deadline's tight. No extensions granted. Now the documents. Okay, the evidence. First document, filed Tuesday morning. I pulled page 23. It says, quoting here, defendants have exhausted this court's patience with procedural delays and incomplete responses. That's not my take. That's the ruling. What it means, judge is done waiting. But here's what got me. Page 31, different section, lists 84 specific document requests that remain unfulfilled. Each one numbered, each one with original deadline, some from 11 months ago. Put those together. Yeah, this isn't new resistance. It's sustained. I went through this 3 times. Patterns clear. Request filed, motion to delay filed within 72 hours, extension granted, then same cycle. All documented across 200 pages of court history. Now, what nobody's covering. Page 39 includes communications between Trump's legal team and third-party entities in Nevada and Wyoming. LLCs established within days of subpoena notices. Read that again. That changes this. Judge specifically addresses these entities, orders disclosure of their formation documents, banking records, and correspondence. No privilege claims accepted. Why Nevada and Wyoming matter. Asset protection jurisdictions. Common in corporate planning. Here, timing raises questions. Fallout. Financial institutions served with direct orders. Accounting firms subpoenaed. Former advisors scheduled for depositions within 8 business days. The ruling also addresses something interesting. Page 14 references encrypted communication platforms. Judge notes that technological obfuscation does not constitute legal privilege. Translation, using Signal or similar apps doesn't make conversations protected. What the order requires specifically, all text messages between 17 named individuals from January 2024 forward. Financial records from 4 specific banks. Meeting calendars and attendee lists for 23 different dates. Each anchor point sourced to exhibits attached to the filing. Third bank listed, Austin-based, handles real estate transactions. $18.7 million moved through accounts in March alone, according to previously filed financial disclosures. Judge wants those records, transaction-level detail. Opposition tried arguing volume makes compliance impossible. Her response on page 42, defendants' organizational choices do not excuse compliance with lawful discovery orders. Basically, being disorganized isn't a defense. One more thing from the evidence section. Page 47, final paragraph before signature. Should defendants fail to comply fully by the stated deadline, this court will consider sanctions, including adverse inference instructions, monetary penalties, and referral for contempt proceedings within 14 days. That's just the first document, so I'm not done. More filings expected. I'll break down what they reveal. Hit that button now. Okay, but look, gotta be fair here. The other side has a point. Few points, actually. Trump's legal team says this is prosecutorial overreach, masquerading as normal discovery. And honestly, some of it holds up. Their argument, the volume of requests is designed to overwhelm, not illuminate. Requesting every communication from dozens of people across years creates impossible compliance burdens. Second, some of these requests genuinely do implicate attorney-client privilege. Not everything, but legitimate questions exist about communications with legal counsel. Constitutional law attorney representing Trump put it this way: no defendant should face discovery demands that would bankrupt compliance efforts before trial. Don't agree with all of it, but that's not nothing. What they've got: prior cases where courts limited discovery scope, examples of requests later deemed overly broad. Even neutral legal observers admit the document volume is substantial. Professor at Georgetown Law noted these discovery battles often reflect broader strategic positioning by both sides. Look, I'm not here to tell you who's right. Prosecution's interpretation, evidence supports aggressive discovery given case complexity. Defense interpretation, evidence there too that some requests exceed normal bounds. Both can be true. That's what makes this complicated. The defense also raises timing concerns. They point out that similar cases proceeded with narrower discovery. Question whether this represents equal treatment under law. Fair point to consider. They've also noted that compliance costs fall on the defendant. Every hour spent gathering documents, every lawyer reviewing for privilege, that's defense budget. In cases involving wealthy defendants, courts sometimes assume unlimited resources that don't actually exist. Former defense attorney with white-collar crime experience said, discovery can become punishment before conviction. The privilege questions aren't frivolous either. Where's the line between campaign strategy discussions and legal advice? When advisors include both lawyers and political consultants in same meetings, what's protected? Legitimate gray areas. What I can tell you, what the judge decided. And she decided that whatever validity those concerns might have in theory, this defense team hasn't demonstrated good faith effort. She pointed to specific instances where partial compliance revealed the full documents existed and were accessible. That changes the equation from impossible request to unwanted request. Which brings us to what happened next. This didn't come out of nowhere. Backstory quick. Nearly 2 years back, initial investigation launches, voluntary cooperation promised. Year and a half ago, subpoenas issued when voluntary production stalls. Year ago, first motions to quash filed. Someone even said on record during a hearing last fall, we risk normalizing resistance to legitimate court processes. What happened? Motions multiplied. Pattern: subpoena arrives, motion to narrow scope filed. Partial compliance offered. New subpoena for remainder. New motion filed. Every time, months added. Until Tuesday. What shifted was judicial patience. This judge specifically has reputation for accommodating reasonable defense requests, extended deadlines before, granted protective orders. But court filings show a progression. Early rulings included language like, the court understands the complexity. Recent ones, defendants provide no credible justification. Tone changed over months. Previous cases she's overseen show similar arcs: initial flexibility, then enforcement when good faith disappears. This ruling represents that inflection point. See where this is going? Hit like. Helps the algorithm show this to people who need context, not just headlines. Monday, 2 p.m. Here's what happened. Emergency hearing. Trump's lawyers request another extension. Discovery demands exceed reasonable bounds and threaten vacations. Judge's response in the official transcript? Room went quiet. What followed? Denial of extension motion. Rejection of privilege claims on 91 documents. Order for complete production by July 15th. 47 minutes. That fast. Now, what everyone missed. While people focused on the disclosure order, something else happened. Judge scheduled a compliance hearing for July 8th, not after the deadline, before. Then issued supplementary order, interim report due July 5th, detailing production progress. That's a Saturday, holiday weekend. Court administrator's response, clerks will be available to receive filings. Wasn't reactive, calculated. You can see it in the scheduling order attached as Exhibit F. Every date chosen eliminates standard delay tactics. No counsel unavailable excuses over holiday weekend. No waiting until deadline to claim impossibility. This is where it gets interesting. The July 8th hearing includes something unusual. Order requires Trump's lead attorney to appear personally and, quote, certify under oath the accuracy of all representations regarding document availability and production status. Not a written certification, in person, under oath. Former prosecutors recognize this move, creates personal liability for the attorney if representations prove false. Legal ethics rules mean lawyers can't knowingly make false statements to courts. This order makes any misrepresentation about document production a potential bar complaint issue. Raises stakes considerably. Don't go anywhere. What I show next changes the picture. Comment below what you think happens at that July 8th hearing. Keep watching. What are experts saying? Former federal prosecutor, 18 years in white-collar crime division. This order reflects judicial findings of bad faith. Courts don't micromanage compliance without cause. Plain English, judge thinks they've been running out the clock. Another one. Constitutional law professor who's argued Supreme Court cases. The privilege rejections suggest prior claims were aspirational rather than grounded in established doctrine. Key there, previous privilege claims may not have met legal standards. Here's what's interesting. Even defense-side legal analyst from a conservative think tank admits the timeline of filings does show an unfortunate pattern. When both sides agree, pay attention. Former assistant U.S. attorney who handled political corruption cases noted something else. In-person certification requirements typically precede contempt proceedings. Judges establish clear record of what defendant knew and when. That's not speculation, that's procedure. Another former DOJ official who worked on document-intensive cases. 14-day compliance window for this volume suggests judge believes documents are readily accessible. Courts don't order impossible tasks. Meaning, judge doesn't buy the we can't find everything argument. Legal analyst who's covered similar cases. Financial institution subpoenas eliminate reliance on defendant cooperation. Banks don't assert privilege. Direct access to records. Consensus among legal professionals, disclosure order is enforceable and likely to survive appeal. Timing eliminates standard delay mechanisms. Personal attorney certification creates accountability. That's where professionals land. Not might happen or could result in. This order has teeth. Useful breakdown? Hit like. Matters more than you think for getting this information out. Why should you care? Real talk. How this affects actual people. This sets a precedent. Next time you're involved in any legal proceeding, divorce, business dispute, whatever, courts may cite this for discovery expectations. Quick example. You're in a contract dispute. Other side requests your emails. You say it's too many to review. Judge points to cases like this. Organizational burden doesn't excuse compliance. Not dramatic. That's how this works now. standard for what counts as reasonable document production just shifted. Affects anyone who ends up in court. If you vote in federal elections, this matters. Sets expectations for political figure accountability. Whether you support Trump or oppose him, having clear rules about document disclosure affects everyone who runs for office. Future candidates will navigate these precedents. Also affects how campaigns structure communications. Knowing nothing's automatically private changes behavior. Could increase transparency. Could just drive things further underground. Either way, your candidates operate under these rules. Right now, legal teams across the country watching this for procedural guidance. Corporate defendants in white-collar cases already adjusting document retention strategies. Hits within weeks as other judges cite this ruling. This case involves $340 million in financial transactions, according to earlier filings. If you have concerns about how political figures handle money, document disclosure matters. Can't investigate without documents. If you think investigations waste taxpayer resources, same issue. Discovery disputes cost money. Your tax dollars fund both prosecution and court system managing these fights. Uncomfortable part. High-profile defendants often get more procedural accommodation than average people. More time, more hearings. If you're not wealthy and you're in court, you probably don't get 17 months to comply with discovery. Not trying to scare you. That's what the timeline suggests. Equal justice question. What informed people doing? Business owners reviewing document retention policies. Political operatives reconsidering communication platforms. Asking lawyers about privilege scope before assuming conversations are protected. Knowledge helps. If you ever face legal issues, understanding discovery obligations matters. How'd Trump respond? Made it worse. Honestly. Statement released Tuesday evening. Didn't address compliance. Attacked judge instead. Called the order politically motivated and witch hunt continuation. Quote, no president has ever been subjected to this level of harassment. Reaction from legal community? 14 legal ethics professors signed letter, noting statements don't constitute legal arguments. Former judges from both parties criticized public attacks on sitting judge. Opposition came back fast. Prosecution filed notice with court highlighting the statement. Asked judge to note defendant's characterization of lawful orders. Then Wednesday morning development, one of Trump's attorneys filed notice of withdrawal from case. Personal reasons cited. No elaboration. That's attorney number 6 to leave this case. Remaining legal team filed emergency motion for extension based on personnel changes. According to the motion filed early Wednesday, transition of counsel requires reasonable accommodation. Judge's response due tomorrow. Legal analysts expect denial. Personnel choices don't typically override court orders. Not cooling down, heating up. What's still unclear, 1, whether Trump's team can actually comply in 14 days. 2, what those encrypted communications contain that's worth this level of resistance. Coming. Court has compliance check-in scheduled July 8th. Trump's team reportedly preparing selective compliance, producing some documents while appealing privilege claims on others. Prosecution preparing contempt motion if production incomplete. Date to watch, July 15th. Full compliance deadline. If documents aren't produced, judges already outlined sanctions. Monetary penalties starting at $50,000 per day. Adverse inference instructions, meaning jury can assume hidden documents are damaging. Potential contempt referral. Also watching July 5th, interim report, first indication of whether good faith effort underway. Appeals court could intervene. Emergency motions expected, should know more within days. Banking institutions have started productions, according to sources. Those documents arrive regardless of Trump team cooperation. Subscribe. I'll break down the July 8th hearing and any new filings. Notifications on so you don't miss it. Where we are right now. Court order in effect requiring complete disclosure by July 15th. 6 different banks served with subpoenas, productions beginning. Trump's legal team down 1 attorney, filed extension request, prosecution preparing for potential noncompliance. Scheduled. July 5th, interim compliance report due. July 8th, in-person certification hearing. July 15th, full document production deadline. Not public yet. Contents of those 127 emails judge ordered released. Those come with the production. Also unknown, what the Nevada and Wyoming LLC records show. Banks processing those requests now. Clocks running. Judge made clear in Tuesday's order, this court will not permit further delay, regardless of defendant's status or position. Appeals possible, but unlikely to stop initial production. Appellate courts rarely intervene in discovery disputes absent extraordinary circumstances. Next major development expected by end of week. That's where we are. Trump's legal team, 14 days to produce everything or face sanctions. Surface read, standard discovery dispute. But the specific language in this order matters. Pattern of delay, exhausted patience, bad faith. That's not boilerplate. That's a judge creating record for enforcement. The timing choices. Saturday deadline for interim report, holiday weekend. Hearing before final deadline. Eliminate excuses. I'll be watching that July 8th hearing. What gets said under oath about document availability tells us what's coming. Story's not over. It's still developing. Subscribe for the full picture, not just headlines. When those 127 emails get released, when the banking records come through, when we see what's in those LLC documents, I'll break down what they actually say. Documents don't lie. They just need translation. Talk soon.